Right, now I want to go and get started. Okay, ex parte emergency custody. That is the way this firm was kind of formed. Um, what when it comes to what a Main Street kind of law firm does, there's a lot of different things that we can get pulled into. But one thing that is going to immediately get a response and to get things moving is when somebody's child is in danger or there's some kind of situation that they feel like they have to have an immediate order from the court. So when that happens, there's a few things that you need to be thinking about pretty quickly. Number one, this person's probably going to retain, right? So I will tell you, and some of you guys that have been doing this for a while, I will pretty quickly go into the discussion about the fees. You guys all know my sort of 10-10-10 concept, the 10 minutes of listening, 10 minutes of sharing, and then 10 minutes of selling. If that kind of goes out the window when I know there's an emergency custody aspect about what's going on. Pretty much if I say like, look, we need to move forward on this right now, it's my suggestion that we go ahead and talk about what a fee is going to look like and go forward. Now, I think, in our family law handbook, we say at least $3,500 if you're going to be dealing with that. I honestly believe you need to be thinking around $5,000. That's just my experience. I'm sure Patrick, Justin, these guys, and I would be able to say, like, look, we've been doing this a lot. I know, Patrick, you've been dealing with several of these over time. It just is going to take some time and effort. And at that point, they're pretty heavily motivated. So, my thinking would be just go ahead and get in your mind, emergency custody, let's just do $5,000 and just get this thing rolling and get it started. Now, Caleb, a lot of the things I'm about to talk about is going to be North Carolina specific because South Carolina is slower about this stuff. I mean, we can kind of take you through that. And at this point, I would certainly recommend you getting Jordan or Rusty involved in one of those cases immediately as that comes in. But I don't think that this part of it still applies. I would at that moment of the consult, when I'd say, okay, it's emergency custody. Let's just go ahead and talk about fees. We're going to charge you $5,000 to get involved in emergency custody. We're going to try to file something today. We're going to move forward with that. All of the spiel that you normally do, but you do that at the top and say that I'd like to go ahead and get started in this. And then at that point, I start my meter running. Consult is over at 10 minutes. We are now in actual work and billing time. So, that's a key part of it. I've never had any client complain. And if you're starting to draft documents, you're way beyond a consult, right? I mean, documents that are actually going to be filed. So that's what I do. I'll just cap my one and just start my billing. I'll tell them, say, look, I'm just going to start the case right now. We're on the billing and get them rolling immediately into the billing at that point. A couple of things that you need to be looking at. First of all, remember, just because the client thinks it's emergency doesn't mean it's an emergency to us, and it certainly doesn't mean it's an emergency to the court. So, of course, you need to make a determination of, is this actually an emergency? And a lot of this is going to come through some experience and knowing your judges, because I have seen some judges grant every emergency kind of filing that's in front of them. They don't blink about it. And I've seen some judges that will not sign an emergency custody. Probably if you showed, the child with a knife in the middle of the stomach. I mean, that is the kind of variance that you're going to get from the judges in terms of what is an emergency and what is not an emergency. In my opinion, we want to lean towards the representation of a client. So in general, if that client believes there's an emergency, we probably should act. We have to assume that they're the parent and they know what's going on, but you will know some red flags about it that it makes it not an emergency. In my, and you guys feel free to jump in on this. Anna, Patrick, Justin, you guys have been doing this a long time. I see Jordan, Patrick, whatever it may be, let me know. But my feeling is a lot of times the clients will say they started dating somebody else, somebody new. Well, that's not going to be enough for an emergency. And I don't know who they are. You're going to have to say to them, that could be an emergency. Okay, no doubt, a new boyfriend, new girlfriend could be an emergency, but we have to know something to believe that they are. In general, if that's the case, I want to refer them to a private investigator and say, hey, we're going to go ahead and start working on the paperwork, but I'm not going to file it until I have something that would be a little bit more. Generally, they're going to know something about this new person. And what we're looking for is a criminal record, felony conviction, certainly a registry type situation. Those are all possibilities. Even something like taking a look at their Facebook and sort of seeing what's going on are all possibilities to be able to say, like, look, this is an issue that's out there. Now, the second thing that you're going to do is, after you analyze the issue, you want to know where the child is. It's a completely different scenario if you're having to do a snatch and grab. You're having to get the child from another place versus keep the child from going over, or keep the child from sending the child, whatever it may be. It also might be that the other person is wrongfully withholding the child, so they're violating a court order. So a contempt might be really what you're kind of doing, but you're trying to get some kind of enforcement of an order that would be a part of that. That's a little bit different than your normal ex parte. Ex parte does require for you to find a risk of substantial bodily harm, or that the child is being taken out of the jurisdiction. So that's a pretty high standard, either one of those. And
I'll add to the child being taken out of the jurisdiction. I've had judges balk at that before too, that it's not just taken out of jurisdiction, it's taken out of jurisdiction to avoid the jurisdiction of the court.
Yeah, for the intent of, it's right. I mean, we live in a lot of border counties, and I hear a lot of like, well, they've taken the child out of state. Well, going to South Carolina, most judges don't even really see that as being out of state, to be honest. I mean, they're going to be thinking in terms of, you better be going west of the Mississippi and without an intent to leave. You need to show that person has packed up their stuff. They don't, you want to be very conscientious about it. And I think what Patrick's alluding to is one step further. Is your credibility on the line. The judges anticipate that we are doing some level of a test to make a determination as to whether or not this is a proper case. And your reputation is on the line with every time you go forward and you ask for an emergency custody. Now, they know that we can get burned by our clients. And I think that most judges will understand that our clients may tell us lies, and we only have a certain amount of duty to override that. But if it doesn't pass that smell test, if it doesn't seem like that there's an evasion or that substantially bodily harm is going to happen, then encourage the client to say, look, we're going to draft this up. And I try to really create that urgency with the client and say, look, we're putting this thing together, but I'm not filing this until I have proof. It's not what you know, it's what you can prove. All those kind of things that we say to clients, but you want to make sure that you know what's going on. Now, there are specific rules in North Carolina about this. Number one is Rule 3.3 of the Revised Rules of Professional Conduct. It says, an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer, which will enable the tribunal to make an informed decision, whether or not the facts are adverse. And I think that the judges do rely on you to say, like, hey, well, they've taken the child out of state, but that they've texted your client 4 times to say, I'm taking the kids to Alabama to go see their grandma. I know you don't like that, but I'm going. And then when they go, that's not an ex parte. It could be contempt, but it's not an ex parte. Or at least you need to go to the judge and say, here's the facts that I know. Here's the 4 texts. You see what I'm saying? I mean, I think that that's required, even if the other side's not represented or anything else. I think the judges have a definite rule that they will lean on. So you need to be asking the tough questions to your client. You cannot be a naive person who just is listening to what their client says. At least ask the tough questions so you can say, here, this is what I'm getting from the client. Now, next thing, after you determine whether or not you're having to get the child, and if you do have to get the child in North Carolina, I think I might bring this up later, but if I forget, you have to also get a warrant to get the child. So that directs law enforcement to do that, because the Court of Appeals in North Carolina has said, unless the order says specifically law enforcement to get the child, and most law enforcement now believes that is the warrant. You have to ask for a warrant to get a child. Then the law enforcement is not required to, even if the order says, all parties are directed, or, government officials are required to. I mean, it has to be very specific as to what law enforcement is requested to do and what they are to do. All right, so after you make those determinations, you have to determine if there is a possible attorney on the other side. If there is a possible attorney on the other side, you have to give them simultaneous notice to the court, or of course before that. Now, Justin deals with attorneys that are more than happy to cite to him the unofficial rules. Well, we around here, we give each other 24 hours or something like that. I mean, it's really funny especially when you get into the more mountain counties, what they'll tell you that, like, I've never seen the rule that says any of those kind of things. The rule in North Carolina is a rule of professional conduct. That's 3.5. A lawyer shall not communicate ex parte with a judge in writing, except for in writing, if it's furnished simultaneously to the other party. Now, you can do that orally, but I don't recommend doing that orally. There's no guarantee that attorney's still going to be the same person when you actually get into court. So my advice is to do that, and it does not have to be a significant amount. I mean, I think that 45 minutes is adequate, but you almost always have some kind of timeline to be able to tell the other side, if there's another attorney or even a suspected other attorney, hey, just want to let you know, I'm going in front of the judge for an ex parte. I'll let you know if the judge orders it or not. And then you copy them on the request to the judge if you're sending an email to the judge, judicial assistant, clerk, whoever you're sending it to. That needs to be done at least simultaneous to the same, that filing. If you do not do this, you will be rightfully get the ire of the court and that attorney, and sometimes forever, just because the attorneys remember that kind of stuff. So, it's not worth ruining your reputation. I know JJ probably can tell you a lot about that, because there's a lot of those kind of things that goes on with the district attorney's office. And when you're working for the district attorney's office, other attorneys are always doing things ex parte, and they're not supposed to be. That rule applies in everything, but it certainly applies in emergency custody cases. You need to let the other side know, and you need to at least copy them in a CC format to anything that touches a judge or judicial assistant. Does that make sense? I don't know about you guys, but I have this. I've been seeing this as a problem recently. I will send something to the clerk's office or a judicial assistant, copying the attorney, and then they will respond to me individually. I don't know if you guys get this. It happens a fair amount. I think that when you respond back, you need to re-add the other attorney. Just because they've kind of invited this to be a little bit off the record, I think it still is best practice, or maybe required, depending on the way it is, to continue to add that person. I just think that they don't really think about rules of procedure. They're just like, oh, let me just ask Brian that, and then they will send it to me. So I think it's good form for us to always add the other side. Generally speaking, you want to do those kind of things anyway, right? Okay. The 15.3.5 says, in circumstances in case rendered appropriate upon gaining jurisdiction, the minor child, the court may enter orders for temporary custody and support of the minor child pending the service process or notice provided. This is called a status quo order. Now, judges hate status quo orders and generally will not sign one. You have to, it allows, basically what it says is a court can enter a temporary order anytime they want to. So you can't just go in front of the judge and say, like, hey, judge, in this new case, I want you to keep everything the same, or whatever it is. Most judges are going to drop past that, and they're going to make a determination. If it's not an emergency, if there's not substantial bodily harm or whatever, they're not going to sign that order. Now, if you do a notice of hearing and both sides are there, the judge very well may do something like a status quo order. But I don't think that the judge wants to do an ex parte status quo order. Now, when I first started practicing, that was very common. The judges would say, okay, I'm making an order. What are the parties doing right now? I'm just going to make an order that nobody refused to exchange the child or the children. And, that was a very commonplace kind of order. Somewhere along the way, at judges school, not really case law, but at judges school said, don't do those status quo orders. Make sure that there's some kind of emergency. If you're doing an ex parte, that's going to be required. So I don't know, have any of you guys seen judges ex parte entering status quo orders? I'm just curious. I just don't think it happens very often anymore. The judges are just like, yeah, go ahead, Marty.
I had a judge, it was Judge Champion over here at Cleveland County. I had entered a status quo order and I knew I was like bordering on the edge of being substantially harmful to the child there. And the opposing party was an ex-judge and she said, those are illegal. And he said, no, ma'am, they're not. And actually, I came to find out later she lost to him. So there was some underground stuff there I didn't know about. And he said, no, ma'am, they're not. And then after he hung up with her, he directed me to go to the UNC government site. He said, there's an excellent paper on it. A status quo order is not illegal. It is very much within the realm of judges to do those. It's just that I'm not sure if you're rising to the level of the bodily harm, like what you said. I kind of used it as there was a psychological harm I felt. So anyway, Judge Champion directed me to that and I started to read it. And then since I don't remember it, I bet you I stopped because something happened and I didn't come back to it.
Yeah, that's what I'm reading off of. The School of Government one that's what every judge is going to read. I mean, a School of Government article to a district court judge in North Carolina is better than a Court of Appeals decision. I mean, they will disagree with the Court of Appeals, but they will not disagree with the School of Government. That's who trains them. And yes, I can imagine that you had Schufert versus Champion, so you got in the middle of a political fight that you probably were unaware of. So congratulations on that, Marty, that you survived. I appreciate you still breathing. That was a nice, difficult case. And I can only imagine the coldness of the room when he corrected her on what the rules are in district court. It's not illegal, but I think that's a perfect example of what we're talking about. It's judges can do it, but they are strongly dissuaded from just doing a status quo order. And I can see why, but technically, if they enter an order like that, you don't have to have a return hearing. It's now the temporary order in the case. So, the judge usually will say, look, I might give you something, but I'm going to have a return hearing on that at a certain date or something like that. Or you may be in the middle of a political fight and you just put your, look at your feet and kind of back your way out of the courtroom. But it is, yes, that School of Government one, and I will send this to you. It's an older article. It's 2011, and a couple of the laws have changed since then. So it's one of those things you have to kind of balance a little bit. But I think it would be completely fine to be able to do that. Okay, remember that if you change living arrangements, then you have to show it, and this is really good to Patrick Keeley's thoughts just a second ago. Here's the actual word of 5013.5 is that the child is exposed to substantial risk of bodily injury, sexual abuse, or there is a substantial risk that the child may be abducted or removed from the state of North Carolina for the purpose of evading jurisdiction of North Carolina courts. So I have had a case before where we were on the FBI database. We found the children. The mom had dyed all of their hair blonde and was living in a barn in Ohio. So it is serious, is what people can do. We did a Amber Alert on that one, which was really interesting. I have sat beside the sheriff while we watched a cell phone ping the the different towers, and it's awesome. I had no idea that they could do this. I mean, honestly, it is like, you know how you see the little bombs drop on the videos and stuff like that. I mean, it is crazy what we can do as far as locating people. But most of the time, it's not that way. You know, it's your client complaining because, you know, mama's going to Alabama or whatever it is. You know, those are the kind of things that you run into. You basically, you don't have a lot of information on this, but one of the things that comes up is, what if you have a previous order? Can you get an ex parte? And the answer, in my opinion, is yes. But the court has to show there's a substantial change of circumstances and that this is now should be the order of the court. So you need to make sure that language is in there saying that whatever the emergency is enough to have a substantial change of circumstances and that this current order is required. Because if it does not say that, it certainly can be just, you know, like, okay, this order is invalid. You have to file in that file in North Carolina. Now, Caleb, again, in South Carolina, you would file a new complaint. But in North Carolina, we have to go and dig up the old file if the child was involved in that, so the court can see it. Still, Caleb, if you were doing it, you would need to get a copy of the old file just to be able to show a judge what's going on. You're just not going to be able to do ex parte in the same way. But in general, what you ought to do is you got to show what the order is. You got to let the judge know what the order is, and you got to ask what's going on, and you need to make sure all of that information is going in there. And you know, it's not. I don't believe that you are bound because there's a previous order. An emergency is an emergency. I mean, it's not, that'd be a ridiculous finding, but you might run into that with a judge. And there is a little bit of case law to be able to show what's going on that. And then again, if you're going to use law enforcement, you really want that to be in a warrant. Law enforcement just will not act unless they have something very specific from the court. And really, let's be honest, it's probably flip a coin if you do have a really detailed order from the court, just because, you know, they don't go to cop school to deal with child custody cases. All right. One of the things I would just say is important is that, number one, if you're doing emergency custody, you need to get the sheriff's department involved in the service of that immediately. So let's just say that you've got an emergency order and the child, you're trying to pick up a child in another state. Then you need to be the one calling that other state's sheriff and department and saying, what do we need to do to make sure that we can get that child when my client gets there? So you need to be the one coordinating that. Don't just give the client an order and tell them to go out of state and get it enforced. Just call the sheriff department. I mean, every county in America, as far as I know, has a sheriff. Maybe they call them something different. I don't know of any state I've ever heard of that doesn't call them sheriffs, but whatever it is,
Constables in Texas.
Constables. Okay. Somehow that fits, and we can get a Texas Ranger. I don't know. Texas is going to be Texas, right? But whatever it may be, make sure that you are the one contacting them, because your client will screw it up. I will just tell you. I mean, let's be honest. They're going to screw it up no matter what. When they show up, they're going to screw it up. They at least mitigate their screw up by you being the one that calls. Don't leave this for your case manager. This is just one the attorney needs to take on the chin and just say, like, hey, my client's going to be in Kentucky and 10 hours. Can you have an officer involved to be able to do this? I've got an order from North Carolina instructing law enforcement to be involved in the exchange. I would say most of the time I get a pretty good response from that kind of thing. Occasionally you get something bizarre, but you just want to send that to send a copy of the order to that state. You really get about as mixed opinion with other counties. You know, you just say, like, look, I got an order out of if it's Marty, I got this order out of Mecklenburg County, it's going to Gaston County, then just you call the sheriff's department and just say, my client is planning on being there at 5 o'clock. It's in Belmont. Can you either have an officer there or maybe one of the Belmont Police Departments if that can help facilitate the order being entered, whatever it may be. You want to be part of that process because service is so important, and that deputy needs to have that paper in hand to give to them as a child comes across. Right? You cannot do this one in some kind of haphazard way. It needs to be, here's what is going on. Now, it's fine to give your client the paperwork. They'll probably screw that up, but they at least are most motivated to get that paperwork to the right officer. So I think that's the best way to do it, but you need to make the call, make sure that those things are going on. If it's all within the same county, I still would walk over. If the sheriff's department is very close to the courthouse, get a copy of the order, say, hey, I will take that over to the sheriff's department right now. In North Carolina, you're generally speaking, the sheriff is going to have responsibility for that, even if it isn't a municipality. So you're going to go over to the civil department at the sheriff's office and tell them kind of what's going on, give them some background, and have the client with you. The DSS is not going to want to get involved in this kind of stuff. It has to be an officer and your client. So it's an awkward scenario to be able to do that. But your client has to be there because no law enforcement officer is going to get a child, put a child in the car, and bring the child to you. I mean, you have to be there. The law enforcement officer will just be there to help enforce that situation. Now, let's say you've gotten your order, you got in service. You are now the hero of your client. You are the white knight who has come in and saved the day. You are the best thing that has ever happened. By God, thank you. They want to shake your hand and say, the case is over. And you say, this is the only good day you are going to have in the entirety of this custody case. Because you have set an expectation so high, there is absolutely no way that they will ever get an order that will look anything like what this ex parte order is. And they will think that it is their God-given right, that Jesus himself has come from above and has anointed them as being the sole caretaker of this child for the rest of this child's life. And by God, finally, literally by God, that everybody knows that he's the bastard and I'm the good guy in the case. Case closed. And you tell your client, you will not get custody after this is done. You will get a joint arrangement of some sort, and the judge will not blink about the fact that there was an emergency at the beginning of the case. In fact, most likely, whatever your client just told you is not the truth and the whole truth. There's something about it where they're going to say like, well, here's the text message where the client said it was fine to go out of state. There's going to be some piece of the puzzle that you don't know about. And the judge, in my opinion, when you go to the return on an ex parte, is absolutely suspicious of your client. Probably kind of suspicious of you, but hopefully, our reputation is good enough that they won't be too suspicious of us. But most likely is going to be looking at your client like, okay, tell me why I had to do that order. And if your client, by God, cannot give you an answer in 3 sentences, then that child is going to go back and your client might be punished in this case. So you need to say like, look, this is if there's ever been a double-edged sword, it is the ex parte, because it cuts tight and it cuts great. And it is a great way to get a child out of danger. But if the other side shows up, you need to tell the client, say, look, this is still a 50-50 case. Because all cases are until one party explains why the other party should not have a split joint custody arrangement. I just feel like that's kind of the world we live with in judges. So like, look, yes, you got 1 week with the child that other parent doesn't have. So this is what I would encourage. Number 1, you got the order, let the other side see the child. I mean, you got the order. So do not let your client take the next 2 weeks in a vacation and and promise the child that they don't have to see their daddy again or their mama again or something like that. Because what needs to happen is, okay, I got an order, clarifies what's going on, let exchanges continue to happen, at least let the child see the other party, and by God, by all means, make sure that there's phone conversations going on during that time of ex parte. The judge does not, I don't care how bad the situation is, the judge does not want it to be that child is now alienated away from the other parent. And I think that the judges will punish us for that kind of circumstance. And you want to be able to say, like, look, when you go back to that return, you can say, like, okay, judge, in my opinion, you want to be able to go back and say, okay, I think emergency averted. We got the child back. We're okay right now. We're willing to back off of our ex parte if we can get whatever this a new arrangement is, or if it's an old order, go back to the order, whatever it may be. That's what you really want to do, because the judge does not want to keep it in place. Now, most of the time, the other side is just getting an attorney, and this is a time to kind of do a quick negotiation. You get a good result, and you kind of move forward on it. But those are all kind of the tricks of the trade that kind of gets you there. Okay, I don't want to run too long. You guys know I try to keep these things pretty short, but that is a very quick overview of what I think is one of the most important parts of what we do. It is a chance to really be a lawyer and make a big difference for your client, but just take it with a grain of salt. It is sometimes the best day you're going to have in that custody case, and it can be a stressful one. But it's a good way to build our reputation. And I think that we really have over time saved some children from some really bad situations because of it. Okay, unless anybody's got anything else, I'll plan on seeing you on Tuesday. Call me anytime. Love catching up with each one of you. I'm going to send this recording out so everybody can just see, hear it. If you've got any comments on it, comment on the email that goes out. Otherwise, see you next week.